May I now request Honorable Justice Shri Sanjay Kishan Kaul ji, former Judge, Supreme Court of India, to deliver his keynote address.
Honorable Chief Guest, Honorable Lieutenant Governor and Governor, eminent people on the dais, members of Parliament, ladies and gentlemen, Namaskar. It's a privilege to be delivering the keynote address at the 14th edition of the Sansad Ratna Awards. Unusually, as a judge, I find myself surrounded by the political system today. A short while ago, Mr. Srinivasan shared the history of the award. I was pleased to hear that it is the only award instituted by civil society to recognize and commemorate parliamentarians who have dedicated their lives to serving our people. After all, the Parliament is the hall of democracy, and that's what takes root from there. What makes the award unique is that the awardees are selected on the basis of an objective performance across party lines and data provided by credible bodies such as PRS and the Lok Sabha Secretariat. The awardees today are all distinguished leaders from across the country who have regard for their sincerity and sense of duty, and above all, a shared vision to India's progress. I extend my heartiest congratulations to each of them and to the organizers. I do not intend to discuss the role of parliamentarians, as that would be preaching to the choir for this. I look to each one of you to lead by example. However, having recently demitted office as a judge of the Supreme Court, I do think the relationship between the legislature and the judiciary is worth thinking about, both as an end and as a means to an end, to strengthen the functioning of India's democratic institutions and achieve the values set in our constitution. Traditionally, the judiciary is seen as a check on the legislature, so much so that a running theme of Indian politics is the friction between the legislature and the judiciary. Aladi Krishna Swami Ahir, a prominent member of the Constituent Assembly, explained that judiciary should not function as a super legislature, since it depends as much on the cooperation between the other pillars. Viewed in this way, the judiciary does not tread into the legislative domain, but reviews the legislative action on the anvil of constitutional values. We are all familiar with the landmark judgment of the Supreme Court in Keshwanand Bharati's case. In this case, the court recognized the power of the Parliament to amend the Part 3 of the Constitution, but carved out the basic structure doctrine, imposing a check that amending power would not extend to the basic feature of the Constitution. Although there have been some instances where courts have assumed the more expansive power, such as the PILs, the judiciary has largely been mindful of the institutional limitations. The understanding, however, is limited in several ways. For example, in view of the relationship between the legislature and the judiciary as unidirectional as opposed to the reciprocal, we are as much a parliamentary democracy as a constitutional democracy. Therefore, it is imperative for the legislature and the judiciary to facilitate inter-institutional cooperation. This can be done through inter-institutional dialogue. Two examples on the way which can be achieved comes to my mind. First, the courts go through the jurisprudence that recognizes the legislature policy discretion. We saw the most fitting example of this recently in the opinion penned down by Chief Justice Chandrachud and myself in Supriyo versus Union of India, recognizing the right of the same-sex person to enter into civil union. While we recognize that there were institutional limitations in striking down or reading in the words of the Special Marriage Act 1954, we set out clear obligations of the state to recognize the same-sex unions and grant benefit under the law. I am conscious, of course, of the fact that this is the minority opinion. The opinions also lay down guidelines to ensure meaningful recognition to the rights of the Union. Significantly, the opinions record the submission of the Solicitor General to constitute a committee to elucidate the scope of the entitlement of the queer couple in the Union, and with that, some contours for the committee to consider. According to me, this was a means for the judiciary to enhance the systematic effectiveness of the legislature without merely invalidating statutory provisions as unconstitutional. The latter is not often easy, as it can create serious gaps in legal protection, and certainly fashioning remedies in this manner facilitates institutional dialogue and leaves the legislature with sufficient discretion and even has the potential to influence legislative outcomes. They identify gaps for other institutions to fill. At the very least, decisions such as these can serve as an important source for parliamentary debates and a powerful tool in the hands of the opposition. That brings me to the second example of the interinstitutional dialogue. Parliamentary debates. Debates can be relied upon by courts not only to interpret the law but also to test the law. This is in addition to their role in democratic politics. For example, the courts are regularly required to interpret statutes in line with its object, which can be gathered not only from the statement of objects and reasons, but also from debates. Justice Lokur put it in perspective when he says, a reference may be made to the Constituent Assembly debates or to parliamentary debates, as indeed to any other relevant material, to understand the context in which the constitutional or statutory provisions were framed, and to gather the intent of the lawmakers, but only if there is some ambiguity or uncertainty or incongruity or obscuring in the language of the provision. Similarly, one of the tests to ascertain whether a legislation makes a reasonable classification under Article 14 of the Constitution is that it should have a reasonable nexus to the object sought to be achieved by the statute. The objective can be gathered from the parliamentary debates. Of course, the objectives must be legitimate. Courts cannot uphold an illegitimate objective. At the same time, debates that reflect the balancing efforts by the legislators of cost benefits assist courts in the assessment of whether the legislation strikes an adequate balance, that is, whether the benefit to the public outweigh any harm that it may cause. As the former Chief Justice of the Supreme Court of Israel, Aaron Barak, puts it, the zone of proportionality is the legislature's kingdom. Keeping the boundaries intact is the judge's kingdom. With courts insisting that all laws measure up to proportionality, legislators too are incentivized to internalize the values that animate the standards of proportionality. Where there are several other ways in which judiciary and the legislature can cooperate with each other, it is important of constructive dialogue that I want to leave you with today. I have had personally the opportunity to discuss with the parliamentary subcommittees dealing with law and other affairs. And I thought those dialogues, whether it occurred in Chennai when they came or in the Supreme Court when I headed the National Legal Service Authority, helped in understanding the perspective of the legislature and also for them to understand what our concerns are. That is why today on the technology issue, the government has been sanctioning the full funds which was required to take the whole working of the court system into a different domain, with technology playing an important role. If this is kept in mind, that we are conscious of it, it will ensure a greater accountability and enhance democratic process. I am sure that the awardees will be conscious of this and they charter the course of India in future. Let me end by saying that one of my former Chief Justices told me once, and I believe that's true, there is always a little underlying friction which arises from the role we provide. The legislature always believes that they have the domain to legislate and they are the elected representatives of the people. All of you are. But the check and balance is then provided in the constitutional scheme, which provides for an administration, a legislature, and the court. And since especially we have a democracy which is first past the poll concept, where most governments would be having almost less than 50% votes, the court plays an important role in keeping a check and balance on the system. So he would say that a little bit of underlying tension is good. If things are very hunky-dory between the judiciary and the executive, then we have a problem. And that, I think, reflects the role of each of us in doing so. My congratulations again for the persons who have been awarded for their achievements. Parliament needs to debate, and I think that's the most important function. I hope that the awardees inspire more of our spirited youth to become parliamentarians. Thank you very much.